So good morning to everyone. Starting our work today on our second conference, I want to start thanking our professor, main guest, Professor David Dyzenhaus, for being here with us once more. I want to thank all the audience in the names of the professors that are here with us today, Professor Ronaldo, Professor José Reinaldo, all the students, researchers. Also thank Arthur and Iago for helping, letting me have the opportunity to help with the organization and be here today also. Today we'll have a presentation of Professor David on positivism and totalitarianism. He has a paper on the subject, which will receive a comment from Arthur Prado after, which is working on a translation of this paper to be published here in Brazil. And without further ado, Professor David Dyzenhaus is a professor of law and philosophy at the University of Toronto, a fellow of the Royal Society of Canada, and a corresponding fellow of the British Academy. We have also in the table Arthur Prado, master in legal philosophy and general theory of law here at USP, and which is now a doctoral candidate. And without any further longer, I want to pass the floor to Professor David Dyzenhaus.
Thank you very much. Thank you. So in a way, the reason that you have the talk and the paper is that at some point a few months ago, Arthur suggested that he would translate one of my papers into Portuguese, and we talked a bit about which paper, and I can't remember why, but I suggested this one, and you said it might be of interest to people in Brazil. And I wanted to say a little bit about this paper, how it got, before I get started on my talk. So that the title is quite provocative: Positivism and Totalitarianism. And there is often this association between positivism and totalitarianism, or positivism and authoritarianism. I think that this association is highly suspect. I'm not actually sure that one should associate legal positivism with what the Nazis did or what any other wicked regime did. But the reason that I have this title is that it was given to me as a task. So there were two people putting together a Cambridge companion to legal positivism, and they invited me to contribute, and this was the topic that was assigned to me. And I could have said no, and partly because, and I was tempted to say no, partly because it's always a lot of work doing these things. I'm never sure how many people read essays in these Cambridge companions and handbooks and the like. But there's also this element of kind of vanity that usually leads me to say yes, and I think that the collection will somehow be incomplete without me. My name should somehow be on the list of contributors. So I wrote a paper on positivism and totalitarianism, even though I wasn't convinced at all that one can make a link between the two. And it was true that in the past, I had thought there was some kind of a link when I did my early work on adjudication during the apartheid era. I tried to show that the judges who I thought were the judges who got things wrong were in a real sense positivists. Why were they positivists? Because they had a certain view of law, which I took from the term from the person who was supervising me at that time, Ronald Dworkin. They had this plain fact view of law. They thought that if there was a problem in legal interpretation, the way to resolve that problem was to find certain facts about the law that could resolve the problem. And I thought at that time as well that if one wanted to find the person in the history of political and legal thought who would give an explanation of why just facts about the law might come with an obligation attached to them, that person was Thomas Hobbes. So I brought in Thomas Hobbes as the person who could explain why positivism could be understood as a kind of authoritarian. Since then, I've changed my mind about a lot of things, most notably about Hobbes, and also about legal positivism, which is why the book which I spoke about on Monday is all about legal positivists. So to the extent that Hobbes is a legal positivist, but the subtitle is Hobbes, Kelsen, Hart, because I actually have come to see over the years that there are a lot more resources in legal positivism than I thought as a graduate student. So now what I'm going to do is proceed through some of the argument of my paper. I was saying yesterday to some of the people who are here that I hadn't realized how dense this paper was. And I think it was Yago who said, well, actually, everything you write is really dense. And I had to say, well, that's not the first time someone has said this to me. So there's significant parts of the paper that I'm not going to talk about. In particular, I'm not going to say anything, or maybe hardly anything, about the long treatment of the grudge informer case that occurs in the paper. But I'm happy to talk about that when we get to a conversation a bit later on. So when I started working on this paper, I wanted to find someone who had actually said something about positivism and totalitarianism. And it won't surprise you that I found this man, who I'm sure is very well known to this audience, Carlos Nino. And Nino, in some of his work, argues that on the basis of his experience of authoritarian regimes in Latin America, positivism contributes to totalitarianism when it is understood not as a methodological doctrine about the nature of law, but as a substantive position, which he terms, and I think he takes this term from Norberto Bobbio, ideological positivism. And according to Nino, this doctrine holds that all power justifies itself, and that the prescriptions enacted by those who enjoy the monopoly of force in a society are in and of themselves reasons for justifying action. So pretty much the view that I had attributed to legal positivism in my and how this ideological positivism might have any connection with what we might think of as something like methodological positivism. That is the kind of legal positivism that at least people in like Hart and those who follow in his tradition think that they are adopting. So they all, of course, distance themselves from what Nino calls ideological positivism. And here's just one statement from Hart's The Concept of Law, which sets out an implication of his separation thesis, that there's no necessary connection between law and morality. And I chose this one because I'll try to come back to it right at the end of my talk today. So Hart, in one of the later chapters in his work on the relationship between law and morality, points to this difference between moral and legal rules. He says moral rules and principles are immune from deliberate change. Hence the idea of a moral legislature with competence to make and change morals as legal enactments make and change law is repugnant to the whole notion of morality. A lot of the paper for today deals with Hart's critique of Gustav Radbruch. And it's in a way kind of ironic that I think that Hart brought Gustav Radbruch to the attention of English-speaking audiences only to demolish him, or at least as Hart thought to demolish him. It so happened that at the time Hart delivered the lecture that became Positivism and the Separation of Law and Morals, a lecture which I think has shapes philosophy of law, at least in English, still to this day. He was spending the year at Harvard talking mostly to Lon Fuller. And Fuller had a lot of Radbruch in his jurisprudence materials, and that's where I think Hart encountered Radbruch for the first time. And he was deeply disturbed by Radbruch. One of the claims that I make in the book a few times is that you can tell when Hart felt most threatened by another philosopher of law when he said the meanest things about him. And this is particularly true of Hart and Kelsen. Hart says terrible things about Kelsen from time to time, and I think it's because he felt most threatened by Kelsen, but he also felt threatened by Radbruch, and so he's really aggressive in his response to Radbruch. So Radbruch, as I'm sure you all know, after the war, in reaction to the horrors of Nazism and what he regarded as the German lawyers' complicity in the Nazi rise to power, and in particular, a kind of positivist mindset among the lawyers that led them to be complicit, advanced what became known as the Radbruch formula, It's quite a long formula, but here I just reduce it to more or less what Hart reduces it to, that extreme injustice is no law. And Hart, in his 1958 essay, when he first sets out the separation thesis, wants to respond to this challenge that comes from Radbruch, that legal positivism has been complicit in moral evil. In the essay, Positivism and the Separation of Law and Morals, Hart accuses Radbruch of naivety. Why? Because Hart says he had only half digested. Can we get rid of that thing? Yeah. I was going to go far, thank you. Had only half digested the spiritual message of liberalism. The message, in fact, delivered by legal positivism, if one says law is law, there's nothing more to law than the law that those with power to make law happen to have made. So that's what law is short for. Law is law tells us that law is not morality, hence it should not be thought to supplant morality. So Hart's claim here is that it's just foolish to suppose that if German lawyers were complicit in the Nazi rise to power, that this had anything to do with legal positivism, because the lesson that legal positivism teaches is that don't think that just because X is the law, X has any moral weight. That's a decision for the individual to make, whether the content of the law is a content of which one should approve or disapprove, whether one should obey the law or not. Don't be deceived by the fact that X is the law, that you have any obligation to abide by it. And he cites, in support of his claim against Radbruch, an example that he takes from John Austin, his positivist predecessor. And Hart quite clearly regards Austin's example as a refutation of Radbruch. In a way, he doesn't need to go any further. All he needs to do is set out this example that he takes from Austin, and you'll know that Radbruch and other natural lawyers are talking stark nonsense. This is what Austin says, and Hart just adopts this idea. So he's accusing Radbruch not only of naivety, but of talking stark nonsense. So what is Austin's example? It's an interesting example. Austin says, suppose an act innocuous that's completely harmless, or even positively beneficial that actually does some good in the world. So I give someone a copy of my book, but one finds out that the sovereign has made giving punishment, giving copies of my book to people an offense punishable by death. So I'm taken before a court of law, convicted, and I'm sentenced to death. And as I'm being led off to my execution, I say, this law can't be law. Why? Because it's against the will of God. And Austin's response to that is, you'll know that it's the law when the noose goes around your neck, right? So that's the example. And Hart uses this example as a refutation of Radbruch. Now, here's something that's not in the paper. It was in the paper originally, but my paper was getting too long, which is always the case with my papers, and the editors didn't like it. So I just took it and put it in my book. So this is in the book. But I actually find it fascinating to look through Hart's footnotes. People often don't spend a lot of time on Hart's footnotes, what one discovers there. So going back to last time, keep in mind that I kind of venerate Hart, even though I sometimes say harsh things about him. He was very careless in his footnotes. He often cited things wrongly, but often the most interesting bits, and maybe this is true of many thinkers, are to be found in the footnotes, because there you'll find the qualifications, the tensions which the person is avoiding dealing with in the text. But this has nothing to do with these footnotes, which one finds at the beginning of Hart's essay, Positivism and the Separation of Law and Morals, because when Hart is setting out his agenda in this essay, and says that positivism has been accused of all sorts of sins by people, and he's going to show that these sins should not be laid at positivism's door, he lists a bunch of figures in the footnotes who have made this accusation. And I think by guilt by association, he thinks they're also guilty of extraordinary naivety and talking stark nonsense. And I think this is, to use Hart's word, an extraordinary charge, because if one actually finds out something about the people he lists in the footnotes, it's very difficult to claim that any of these people were guilty, at least of extraordinary naivety. So one is the Italian historian of thought, A.P. Don Trev. Don Trev fought as a partisan in his native Italy during the Second World War, unlikely to be an extraordinarily naive man. Wolfgang Friedman, another person whom Hart seems to accuse of extraordinary naivety, was a private lawyer in Germany, then a labor court judge, until forced as a Jew to leave his post in 1934. Radbruch, the direct target of Hart's accusations, had been Minister of Justice in the Social Democratic government in the early years of the Weimar Republic until he was forced by the Nazis into retirement in 1933. And the last person that Hart mentions in his footnotes, Arnold Brecht, had been a very senior civil servant in Germany, and he appeared for Prussia in the landmark case in 1932 when the right-wing federal government mounted a coup against the socialist-dominated Prussian government, thus preparing the way for the Nazi seizure of power. This, by the way, is a fascinating case. I've written quite a lot about it, as others have. It's a case where Brecht appeared for Prussia, but it's also a case in which Schmidt appeared for the federal government, and then my favorite Weimar legal theorist, Hermann Heller, appeared for the Socialist Party in Prussia. And if one reads this case, one can actually see the arguments that people make in their academic articles appearing as legal arguments. If one has some access to German, it's a fascinating case to read. All right, so now I want to set out on my path to trying to show why there is some contact between Hart's legal positivism and the charge of totalitarianism. And the way the argument proceeds, and this came about through writing the paper, is that suddenly struck me something that I suppose should be really obvious, but it hadn't occurred to me before, that the way that Hart structures his argument is really, really significant, because he structures his argument in such a way as to make it easier for him to deal with the people whom he opposes. So if one goes back to this essay, Positivism, the Separation of Law and Morality, is divided into 6 parts. The 6th part I'm not going to say anything about. It's just Hart's conclusion to the essay in which he draws various threads together. It's not that it's unimportant, but the substantive parts of the essay are, as I set them out on the slide, that in part 1 of the essay, Hart sets out the moral virtues of the separation thesis as his kind of legacy from the positivist tradition bequeathed to him by Bentham and Austin. Part 2 argues that he has to leave large parts of this tradition behind. Most notably, he has to get rid of the command theory of law, not only because law is not a giant gunman, law is not the gunman situation writ large, as he says, but also because the idea of law as the commands of a legally unlimited sovereign fails to explain much of legal order, including the fact, something which I dealt with a bit on Monday, that nothing which legislators do make law unless they comply with fundamental rules specifying the essential lawmaking procedures. So in part 2, he embraces what gets called the separation thesis, but then ditches large parts of the command model of law that Bentham and Austin had put forward. And then part 3, we get the section which then becomes the site of the debate between Hart and Dworkin, where he sets out his core penumbra model, according to which judges exercise discretion in cases in which what the law requires is controversial. And then in part 4, we get his refutation of Radbruch, and Hart moves from part 3, where he's dealing with the separation thesis and cases where it's controversial what the law requires, to part 4, where he thinks it's uncontroversial what the law requires, but what the law requires is something that's morally bad. And then the question for him, well, how does a separation thesis help a judge or a legal subject who's confronting a law, the content of which is clearly morally terrible? And then part 5 of the thesis, the penultimate part, am I causing this thing to appear, or is it just happening?
I think it appears
on
its own, actually.
So I just get this bar across my slide, which makes life.
I don't think so.
Yeah.
I'm not sure if we can.
Okay, that's okay. I can kind of remember what's there. could always look back up there. So the last part concerns the natural law challenge to legal positivism at the most general level, at the level of legal order. And there, Hart makes what appear to be some concessions to natural law. And what I'm going to suggest to you later, but I want to signal this to you now, is that if we reverse the order, it makes a huge difference. That is, if we start with part 5, then move through part 4, through 3 to 2, leaving out 1, we get a completely different picture from the picture that emerges because of the way that Hart structures his argument. And I point out in the paper, but I'm not going to deal with this today, at least in my presentation, happy to deal with it later, that one finds exactly the same structure in the concept of law. So Hart postpones in the concept of law his treatment of the relationship between law and justice to chapter 7, law and morality to chapter 8, law and morality to chapter 9, and then chapter 10 we get his rather strange account of international law. And again, I think that if he reversed the order, we would get a very different and maybe richer understanding of law. What I want to focus on for the moment is part 4, where he deals with Rudbrook. And there he summarizes Rudbrook for the moment in quite a sympathetic way. He says, Rudbrook's considered reflections, that is, reflections on the Nazi experience, led him to the doctrine that the fundamental principles of humanitarian morality were part of the very concept of recht or legality, and that no positive enactment or statute, however clearly it was expressed, and however clearly it conformed with the formal criteria of validity of a legal system, could be valid if it contravened basic principles of morality. This doctrine can be appreciated fully only if the nuances imported by the German word recht are grasped. And what Hart is referring to here is what I have on the other side of the slide, which will, of course, be familiar to all of you here, as I imagine speakers of Portuguese, that in most European languages, there are 2 words for law that stem from the Latin jus and lecht, and English has only 1, which is law. And there's no equivalent in English for rechtsstaat or état de droit, or what I found through the help of Google Translate, which I will now massacre for you, Estado de Direito. Is that more or less right? So in English, the closest equivalents we have are something like rule of law or legality, and you'll see Hart himself adopts the translation of legality for recht in the quotation there. And this is a term that you don't often find in Hart, legality. Normally he talks about validity, hardly ever talks about legitimacy, but he also hardly ever talks about legality unless he's responding to someone like Fuller. And Hart says, just to repeat, that Rudbrook's doctrine can be appreciated fully only if the nuances imported by the German word recht are grasped. But Hart takes no time in chapter 4 to discuss any nuances. Why? Because he then wheels in the example that I had on the slide a moment ago from Austin and refutes Rudbrook with the example. Where does he deal with the nuances? He deals with the nuances in the next section of the paper. And that, as I say in the paper, this is just a paragraph quoted from the paper, was a consequential deferral. Because what Hart does in part 4 is he puts forward a kind of caricature of Rudbrook's position, which I call positivism with a minor side. So for those of you who are in my lecture on at the beginning of Monday, but I'll repeat it for those who weren't, I offer this very simple example of a rule of recognition, which is you have a monarch who makes his laws known to the people by writing those laws down on a notice board in the town square. So Hart's view of Rudbrook is that's your legal society. You look to find out what the law is of the legal society by looking on the notice board. If any of those laws are morally atrocious, you just take them off the notice board. So it's positive with a minus sign. He thinks of Rudbrook's position as holding that law is what positivists say law is, which is law that's produced in accordance with the criteria of validity in a legal order, but minus those laws that are morally awful. And if that were Rudbrook's position, then it would indeed lead to what Hart calls the dire confusions that he says can be avoided, only if we speak plainly in saying that laws may be evil, but too evil to be obeyed. Okay, now I want to move to part 5, where Hart deals with natural law, and the two arguments that he wants to take seriously when he's considering what one could say about the relationship between legal order and morality, that is moving away from the relationship between particular laws and morality to looking at legal order as a whole. And he sees two possible arguments: that the necessary connection between law and morality is at the level of legal order rather than with particular laws. And the first argument is that there are certain facts about human beings that you will find law takes into account wherever you find law. Human beings are physically vulnerable, they need food. If you imagine these facts as otherwise, that human beings can't be hurt, don't need to eat food to survive, then we would not need rules about property and violence and so on. So he takes the natural law argument to be that all legal orders have such rules. Given these natural facts, these rules overlap with morality. Therefore, there's a necessary connection between law and morality. And Hart has two responses to this natural law argument. The first is, you get through the picture on the slide. Hart says, well, imagine that instead of law for human beings, we had law for giant crabs. Law would be completely different. So crab law would be very different from human law. And this, I think, tells us that for Hart, one can't make a conceptual connection between law and morality, because we could have law for crabs, which would be very different from human law. And therefore, we shouldn't think that there's some kind of necessary overlap between law and morality that comes from the fact that law for people. Why? Because law for people will always have a certain kind of content. What's the second argument? So this will be somewhat familiar to you from the lecture on Monday, if you were here, is that in all legal orders, there are requirements of generality, that like cases should be treated alike, and natural procedural justice, principles of objectivity and impartiality in the administration of the law will exist. And Hart's answer is, yes, that's true, but a legal system that satisfies these minimum requirements might satisfy with the most pedantic impartiality as between the people affected, laws which were hideously oppressive and might deny to a vast slave population the minimum, and I can't read the rest, protections from violence and theft. And the slide from last time, he has an illustration of what Hart has in mind with the pedantic impartiality. It's a beach sign from the apartheid era, which tells people that only white persons can be on this beach. And it's actually a criminal offense if you're a person from another group to go onto the beach. And Hart's claim is, well, you know, that's a law. It's general. It's public. It can be applied by judges. If they apply it with pedantic impartiality, it's only going to make matters worse. It's just going to revisit discrimination on the people who are subject to the law. So don't think that because in all legal orders there are these requirements of generality, treat like cases alike, etc., that tells you that there's any connection between law and morality. So what's my argument against Hart? My argument against Hart is that, actually, if you'll give me just a second, I'm going to, because I am going to lose my thread if I be easier for me if I work off the screen. Yeah. So there's my argument has two components. First, there's Hart's claim that law is no more than positive law with the content it happens to have. And I think that's uncontroversial about Hart, and it is what gives him a great deal in common with Kelsen and Kelsen's claim that law can have any content. And Hart argues, and we've already seen this, that once one understands that there's nothing more to positive law than the content law happens to have, that positivism helps the good liberal citizen to avoid what he takes to be the two major traps of natural law thought. That is, either supposing that because X is the law, X is moral, or that X fails to be a law simply because it is morally bad. So it's Radbruch who falls into the second trap, it's the ideological positivists who fall into the first trap. So that's the first component of my argument, and I take that to be uncontroversially stating Hart's view. The second component, and I take this also to be uncontroversial, is Hart's claim that law must be understood as a matter of authority. Right? So this is his major complaint against the command theorists of law, Bentham and Austin, that they reduced law to the gunman situation writ large. And so a large part of Hart's work, and in particular of the concept of law, is trying to understand what it means to work out what law is as a matter of authority rather than as a system just of coercing people. So I think on the basis of these two components, one can establish a kind of link, and I'm not using kind colloquially, just to qualify my claim about the link between positivism of Hart's sort and what Nino calls ideological positivism. Because I think Hart, in putting forward an argument with these two components, sets himself a puzzle. And this, again, is just a quotation from the paper, which I want to go through with you. So I asked the question in the paper, how can one consistently deny a necessary connection between law and morality and assert a necessary connection between law and authority? So this is something that we spoke a bit about in the Q&A on Monday, but we might speak a lot more about it today. Oh, sorry, I got so infatuated by my own computer that I forgot about this one. So if the latter is the case, that is, if one asserts both a necessary connection, but denies a necessary connection between law and morality and asserts a necessary connection between law and authority, I think that one can make the claim that positivism of Hart's sort turns into ideological positivism. How does that come about? So this is where things get controversial, right? Those subject to the power of a de facto sovereign must understand that his law is authoritative, whatever its content. And if that's right, if those subject to the power of a de facto sovereign must understand his law is authoritative, whatever its content, then I think what one has in place is ideological positivism. And in later work, Hart frankly confessed, so this is in his essays on Bentham, that he lacked the resources to deal with this kind of puzzle. So this is in his response to Raz in essays on Bentham, but he thought that he could stick with the suggestion that whatever the authority of law is, it is not moral authority. And this suggestion relies on the claim in both positivism and later work that there is no conceptually necessary connection between law and morality. Any concessions to natural law depend on contingent facts about human beings and the world we happen to live in. So in a way, Hart's response, if one could pose this puzzle to him, would be, well, what about crab law? Yeah, okay. Dealing with two computers is beyond me. So, okay, thank you. So where does the problem come from for Hart? So I want to claim, and this is meant to be provocative, that Hart's legal positivism becomes linked to ideological positivism because of the separation thesis. So because of the thesis that there's no necessary connection between law and morality. So I say in the paper, somewhat paradoxically, it is the separation thesis that provides the link between positivism as a theory of law and ideological positivism. Ideological positivism is a product of two elements. First, a version of the separation thesis, the claim that the law that governs us is the law with the content it happens to have. And second, the claim that law with that content must be understood as a matter of authority, not as the gunman situation writ large. Moreover, I suggest, from the perspective of the officials of the legal order, as well as other participants in it, including lawyers and those subject to the law, the separation thesis understood as requiring that we view law as normatively inert, a term that I take from John Gardner, is not an option. It's not an option for lawyers and officials to say of the law, well, those are reasons, but those reasons carry no weight. Those are reasons, but they're normatively inert. That's just not an option for officials, and including judges. And we know that it's not an option because Joseph Raz has told us that it's not an option. The law will claim authority over them. And as Hart's most influential student, Joseph Raz, has argued, it's not only the case that the law necessarily claims authority, but also the claim is necessarily to legitimate authority. And Hart tells us, at least Raz tells us, this is the element that Hart rejected, something I should have put on the slide, but forgot to put on the slide, that when an official tells someone what to do, like a judge, it is the case that the official must ally himself with the law's claim to legitimate authority, even if the official, even if officials in their hearts don't believe that claim. In telling someone what to do, you are telling them what they, morally speaking, ought to do. That's precisely what Hart rejected as a moral component in Raz's theory. But as you'll recall from the slide a few moments ago, Hart confessed that he himself didn't know what to make of this problem, that his theory of authority seemed to suggest that law is, as Gardner called it, normatively inert. Right, so how does one deal with this problem? Yeah. So the place to begin, and this is something that I suggested later when I set out the order of Hart's argument in Positivism and the Separation of Law and Morality, an order which I suggested to you is then reproduced in a way in the concept of law. The place to begin is where Hart ended his main discussion in the 1958 essay in part 5. So if we go back to Hart on natural law, his account of legal order, what he takes to find in every legal order that is a legal order for human beings, not crabs, that one will find there is what he calls later in the concept of law, the minimum content of natural law to be found in every legal order. Why? Because law is going to cater to human vulnerabilities in particular ways. So one finds that. And not only that, but one also finds these dimensions of legal order, like law must generally be general, like cases must be treated alike. As I mentioned on Monday, Hart and then Raz more or less fully accept everything that Fuller had to say about principles of legality, but just reject that Fuller claimed that a legal order that's by and large compliant with principles of legality will produce laws that have a moral quality to them. But I think if one starts with that account of legality that Hart gives us in 5 and then moves back through the essay, we get a very different picture of the problems that he deals with in the essay. Why? Because if we go to part 4, the section where he deals with Rudbruch, it becomes a problem for a judge confronted with a law that on its face looks morally bad, that the law on its face looks morally bad, because the judge has to think, well, I understand that to be a judge in a legal order, law is supposed to and does have this minimum moral content. I understand that there are principles of fairness and so on, and yet the law seems to treat this group of subjects in a way that is in severe tension with my understanding of legal order. And that poses for the judge an interpretive problem, how to try to find an interpretation of the law that will fit better the judge's understanding of the purposes of law, the values that law is supposed to serve. And then the judge might find that the law doesn't actually have the immoral content that it seemed on its face to have, but a different content, which a judge gets to through legal interpretation. Why? Because that's how the judge understands, to use a Fullerian term, his obligation of fidelity to law. It's not fidelity to just the content of positive law, it's fidelity to legal order, which requires a judge to interpret the law in light of the judge's understanding of the values that legal order is supposed to serve. And then if we go further back to the section where Hart deals with adjudication, his core penumbra model, part 3, then the problem of discretion, I think, looks very different. So the judge is presented with a controversial case, but the judge doesn't say at that point, well, it's controversial what the law requires. I'm on my own here. I should just decide as best I can, the judge will try to make a decision, and there are going to be hints of Dworkin in what I'm going to say, but actually Fuller said things like this well before Dworkin. In fact, Fuller anticipated much of what Dworkin had claimed he had invented all on his own. The judge will have to have regard to what the judge regards as the principles of legal order. Perhaps one might think of them as the unwritten principles of legal order, and that will inform the judge's interpretation. And once that happens, then the space of discretion starts to narrow to vanishing point. And if one does all of that, I think one gets a much richer understanding, much more complex understanding of Hart's legal theory than Hart himself gives, but one has to start in a place where Hart didn't start, which is usually towards the end of his work, whether it's the end of the essay in 1958 or the last 3 chapters of the concept of law. And if we do that and we leave out of the picture what Hart says in part 2 of the essay, then we can understand better. Oh no, so we want part 2 as well, because part 2 tells us how an understanding of law as a matter of authority relates to the way in which in any legal order, fundamental legal principles condition political power. Right, so I think that has to be included. And if we have that in place, starting with 5, going through to 2, then we can understand better, as Kelsen once put it, how might is transformed into legal right. That is how, in a legal order, political power gets converted into something that we can call legal right. And all we have to leave out is the insistence on the separation thesis in part 1, for the 2 reasons my argument here supports. First, it is the insistence on the distinction between law and morality, and that has the perverse effect, I claim, of turning right into might through the claim that law as such has authority, whatever its content. And the second thing I want to say is that natural law positions about law's moral quality are not, as Hart charged, naive. Rather, in their different but perhaps complementary ways, they are seeking to elaborate the moral resources of government under law that make it plausible to claim that law should not be understood, as Hart thought, as the gunman situation writ large. Right, so that brings me to the end of the presentation of the argument of the paper. And I wanted to say just a little bit about the project that I'm working on now, which relates a little bit to the discussion on Monday, in particular to the issues that Thomas Bustamante introduced when he gave a comment on my paper, which, or at least my lecture, which dealt with the difficult issues once one tries to understand law as a pragmatist philosopher might understand law. So if you go back to the slide, one of the slides I started with, Hart's claim that moral rules and principles are immune from deliberate change. Hence, the idea of a moral legislature with competence to make and change morals, as legal enactments make and change law, is repugnant to the whole notion of morality. I think that's wrong. And I think that one can see why it's wrong by trying to reconceive the enterprise of philosophy of law and the place of legal positivism and natural law within that enterprise as different kinds of institutional inquiry into our moral experience. So let me just say a little bit about this, and then if people want to challenge me on this, and it's going to be rather enigmatic, so I'm happy to try to elaborate to the extent I can on what I'm about to say. It's very interesting to look at the trajectory of legal positivism. So this is an argument within legal positivism, not an argument between legal positivists and their critics, the trajectory that goes from Bentham through Austin to Hart. So let me say yet another mean thing about Hart, but remembering, and I mean this sincerely, my veneration for this philosopher of law. Hart, I think, did a great disservice to philosophy of law in the way that he portrayed other people, in particular his positivist predecessors. So philosophers of law, for the most part today, do not care about, and many of them are legal positivists, do not care about the history of philosophy of law, of philosophical thought, and they don't look to Bentham and Austin. Why do they not look to Bentham and Austin? Because they trust Hart, that Hart had put Bentham and Austin behind him, especially in the concept of law. But if one goes back to Bentham and Austin, one actually finds that they were rather different from the way that Hart portrayed them. There's been a lot of scholarship on Bentham in recent years, with one of the most prominent scholars, someone whom you've been reading in a class this term. That's Gerald Postumer, his wonderful book, Bentham in the Common Law Tradition, which is actually quite an old book. It came out when I was a graduate student. But more recently, the work that's been done by Philip Schofield and a group of Bentham scholars at University College London, where the Bentham archive is. I don't know, has anyone here been to University College London? Because if you have, or maybe you know this from just reading, Bentham bequeathed his auto icon, that is the mummy of his body, to University College London. And in one of the halls in the main building, you can still see Bentham sitting on a chair. It's not quite Bentham, because apparently they didn't do the embalming job very well, so they had to replace his head, but they replaced it with something that looks like Bentham. And they still wheel Bentham into Senate meetings in University College London. So Bentham is a big deal at University College London. And that's why the Bentham project is located there. But the Bentham scholars, in particular, Philip Schofield, have argued, and I think convincingly in the last few years, that Hart completely misunderstood Bentham. Bentham made a distinction between expository and censorial jurisprudence, with expository jurisprudence being kind of descriptive, conceptual analysis of law, and censorial jurisprudence being the project being engaged in when we criticize the law. And we find the same distinction in Austin. He takes it over from Bentham, and one gets the famous sentence in Austin, which Hart then makes the basis for his claim about the separation thesis, that the existence of law is one thing, its merit or demerit is another. But it's quite clear that if one looks at the way that Bentham understood his project, he understood his project as a project of, let's call it, utilitarian legal positivism. So Bentham starts with the equivalent of part 5 of Hart's separation of law and morals, or the equivalent of chapter 9 of Hart's The Concept of Law, the relationship between law and morality. And he sets out his view of utilitarianism, and then he crafts a theory of law that is meant to be in the service of his conception of appropriate moral inquiry. What is appropriate moral inquiry? Appropriate moral inquiry is inquiry into utility. And what will inquiry into utility look like if we give it institutional shape? Well, the kind of institutional shape we give it is we want to find out what the majority's preferences are, get those preferences translated into law, get that law implemented so as to serve the greatest happiness of the greatest number. And that's why one should design legal order so as to have a supreme parliament that can deliberate about, gets elected by people to represent their preferences, can then deliberate about the best way to implement those preferences, then can enact law to implement those preferences. And then you want judges as confined as possible in their role, because you don't want judges second-guessing the legislature as to what will make people happy. That decision has already been taken by the legislature. And then the conceptual part is working out what it takes to put such a legal order in place. So that conceptual part is in the service of the prescriptive part. And I think that's pretty clear in Bentham, at least if one is convinced, as I'm convinced, that Schofield and others are right about Bentham. So let's just move to Austin quickly. Austin has exactly the same methodological structure as Bentham in his lectures on jurisprudence, which people very rarely read. So the first 5 lectures of Austin's lectures on jurisprudence, the first lecture, he sets out the plan of the whole book. Well, it's in fact 2 big books, so it takes him some time to do. And then lectures 2 through to 5 are Austin's understanding of moral inquiry, which is also utilitarian. And Austin has this view that what morality is what God wills. So it's what God would command us. But he tells us that that we are unable to discern either through revelation or through secular inquiry what God's will is. So the closest approximation we can have to what we might think of as moral objectivity, which is what I think Austin uses God's will to describe, is through the kind of inquiry that utilitarian political philosophers would recommend. That's an inquiry into what's good for us on the basis of our experience. And then how does one shape that inquiry institutionally? Well, it's through putting in place a supreme legislature. But then Austin, unlike Bentham, doesn't trust democracy as much as Bentham did. So he's prepared to give a much larger role to judges than Bentham did, and actually thinks it's a good thing if judges exercise discretion a lot of the time, because he's more willing to trust the judicial elite than the views of the population. And that then creates the space in which philosophy of law after the Second World War operates, because it turns into an argument between Hart and Dworkin about discretion. I think there's a different way of understanding this inquiry into moral experience, and that is one takes legal order to serve certain values, and one could say, to put a kind of liberal spin on things, that those values are the liberty and the equality of the individual, and that will then shape one's understanding of appropriate institutions in a different kind of way. So one way in which it could shape things differently is one might get an argument, like the argument that people like Ronald Dworkin make, that in order to do this process of inquiry into our moral experience appropriately, we need to have a body of officials independent of the legislature who can tell us when the legislature is subverting the values that we take legal order to serve. So then we need an independent judiciary that has the authority to strike down legislation when the legislation violates whatever our conception of fundamental individual rights happens to be. But if we have this view of what philosophy of law is about, I think it's very different from the standard view, and I think it casts Hart's argument in a different light. And if we cast them in this different light, then I think we can sever any connection between legal positivism and ideological positivism, but it takes ditching the separation thesis in order to separate, to affect that separation of legal positivism from ideological positivism. And that I regard as a series of very provocative and maybe, as I said earlier, enigmatic claims. So that's where I'm going to end.
Thank you very much, Professor David, for the great lecture. I pass the word now to Arthur for his comment.
Good morning, everyone. Thank you, David, for this amazing talk. I don't really have a comment. What I do have are 2 questions that are meant to prompt you to speak a little bit more on issues that I think may spring to mind of Brazilian readers who read your paper. So my first question is properly a linguistic question. As I was telling Martin earlier, 2 of the main difficulties I had when translating your paper, the first one had to do with retranslating your own translation of Gustav Hadbruch, because of course, you admit to making some choices that are not the most orthodox ones. For example, the word Zweckmäßigkeit, which is translated to purposiveness, which appears not to be a consensus in English. So this was an interesting problem. But the one I want to ask you about is about the word authority. For some time, I was wondering whether this word should be translated into Portuguese to autoridade, which is the obvious literal translation, because I had the impression that this double possible meaning of authority in English as de facto or de jure didn't correspond perfectly well to the meaning we ascribe to the word autoridade in Portuguese. I thought we tended to associate it with de facto authority in the meaning of the efficacy of a legal system, the likelihood that people obey laws or regard them as something they ought to obey. I ended up being persuaded I was wrong about this. I translated the word as autoridade in Portuguese, but I still think it could be useful if you could comment a bit on how you use this word in your own work and how you think Hart uses this word when you say that he believes that law not only claims but does have authority. So the whole government situation writ large issue. So that's my first question. And my second question has to do with Kelsen. This, of course, is not an issue you directly discuss in your paper. It might be the subject of a possible second paper, or I don't know. But I still think it's useful to get you to talk a little bit about this for a few reasons. So, of course, Kelsen, we discussed Hart in Brazil. He's a very well-discussed author. But Kelsen is probably the first positivist that springs to mind when we think of positivism. And historically, he was also someone who was concerned with this accusation that positivism helped enable the Nazi regime to rise in Germany. So he did respond to this in the 1950s in a paper called The Foundations of Democracy. So it's something that was very much on his mind. And a third reason why I think Kelsen is relevant is because, as I commented with you earlier this week, he gave an opinion for the Brazilian Republic in the 1930s, just after Getúlio Vargas assumed power after a coup d'etat. So Getúlio took power in 1930, and soon afterwards, the new regime attempted to pass a new constitution. And they asked Kelsen whether they could legally do so. And he replied in a legal opinion. I'll just read the first question and the first few sentences of his answer. So one of the questions was, I'm translating for Portuguese, so sorry if it's a bit clanky. Does the provisional government, which is a de facto government originating from a revolution, have the right to impose internal rules to the National Constituent Assembly? Kelsen's answer was, there is no essential difference between a de facto and a de jure government, either in international law and even less so in the field of constitutional law. Taking for granted that the provisional government is the highest legislative authority stemming directly from the revolution, without a doubt that government is able to summon and determine the competence of the National Constituent Assembly. So here he makes a very stark separation between de facto and de jure authority. I was wondering how you read him on that. I know that your own interpretation of Kelsen might differ a little bit from his orthodox reading, but it is true that he makes a perhaps more of a stark separation between the jure and de facto authority than Hart does. So I'm curious what you have to say about that. Thank you.
I think I might actually have the same answer to both questions, but I'll see as I go along. You brought up this issue of purposiveness. So I'll just say a little bit about it, why I translate Rechtmäßigkeit as purposiveness. I'm sure there are many people here who know German much better than I do, but Rechtmäßigkeit is, like many German term is a very difficult word to translate into English. I mean, it means something like appropriate to Recht. So not appropriate to Gesetz, to Lex, but to Jus. The Paulsons in their translation, and I've never met Bonnie Paulson, but I know Stanley quite well, and he speaks German almost as a native speaker, which I'm far from being able to do. And so I trust his German more than I trust mine. They came up with this idea of purposiveness as a way to translate Radbruch's Rechtmäßigkeit, and actually it struck me as about right, but maybe for different reasons from the Paulson's reason. And that is, as I suggest in the paper and at greater length in my book, that Radbruch, and this is true of Radbruch before the war as well as after the war, had very much the kind of methodology that I talked briefly about at the end of my presentation today. That is, he wasn't, as he's often claimed to be, a legal positivist before the war. He thought that legal order, as it were, in its nature, served certain values. And for him, I think Rechtmäßigkeit was appropriateness towards serving these values. So I like the term purposiveness, perhaps for different reasons from the reasons that the Paulsons chose it, because I don't mention this aspect of Radbruch. At least Stanley doesn't in his work on Radbruch. But just to say a little bit more about what I do in part in the paper and at greater length in the book, I think that often in that translation of Radbruch's essay, and in particular within the Radbruch formula, there they actually distort Radbruch's meaning, because they tend to translate Recht as Gesetz. And I think that happens because Stanley is some kind of legal positivist, and so he automatically thinks, well, when I see Recht, I'll translate it into English as law rather than right. So I think it makes a great deal of difference, as I tried to do it a little bit in the paper, but at greater length in the book, to actually put Recht back into that passage. I think one gets a rather different understanding of Radbruch. But that's not what you asked me about, but I wanted to say something about it. But maybe it does pertain to this issue of de facto authority. So I'm fascinated to learn that in Portuguese, authority seems to be much more much closer to what we in English would call de facto authority.
I think so.
Yeah. Yeah.
I'm not sure.
Oh, we could have an argument among the people here about this. I think that that English, if that's right, is much more ambiguous when it comes to authority, because I think in English there's always this ambiguity about whether one means legitimate authority, de jure authority, or something else. And that makes discussions of authority in English very difficult. So if one looks at one of the essays that has really shaped the debate in English in the last, I don't know, 40 or 50 years. So one of the essay, I think Raz called it Authority, Law, Morality, where he first gives a complete view of his account of authority and how that translates into an understanding of the authority of law. There he clearly makes a distinction between de facto and legitimate authority. And he also puts forward the argument that the law necessarily claims authority, although that comes with a very heavy qualification that we shouldn't suppose that the law has legitimate authority merely because it claims it. And I think Raz at no point in this essay, particularly when he deals fleetingly with issues like Nazi law, he doesn't tell us that whether because Nazi law could have no authority, therefore it couldn't make the claim to have authority, and therefore it wasn't really law. I think it becomes really ambiguous what Raz thinks about these issues. Why? Because he works continually with this ambiguity in English between legitimate and de facto authority. Sometimes he's clear, and sometimes he isn't. But even if one tried to, and this is why I think my answer to this question starts to shade into my answer to the second. Even if one says, well, all we legal scholars have to be concerned with is de facto authority, we still have to understand what it is for the law to exercise authority. And this is why I think there's a helpful distinction between Hart and Raz, in that Raz always says that the law claims authority, whereas Hart thinks that the task for philosophy of law is to explain the authority that law has. Because for Raz, law will cease to be authoritative if its claim to authority doesn't work. But you'd never find anything like that in Hart. For Hart, law, as I put it, necessarily has authority. So what is that authority that law has? And the point of the argument that I make in the paper and at greater length in the book is that if we work backwards in Hart, from part 5 of his essay to the beginning, or from chapter 9 of the concept of law back to the beginning, we can see that that a de facto legal order will work in such a way as to create, if you like, legitimacy, that the obligations that come about through the workings of a properly functioning legal order will be obligations that it would be a mistake to call normatively inert or morally inert. Why? Because they will have force, moral force, for those who live subject to the order. So the workings of de facto authority create legitimate authority for that order. Now, I'm not sure whether this claim, if it can be made successfully, does respond to your second question, but it may. It would respond to it insofar as I think, on my understanding of Kelsen, you put it as Kelsen makes a sharp distinction between legitimate authority and de facto authority in this piece. I actually think that Kelsen never makes a distinction between legitimate authority and de facto authority, because for Kelsen, all there is de facto authority. And legitimacy, questions about legitimacy are questions for another discipline, political theory or moral philosophy. And all he's concerned with is the de facto. And so he thinks that the only question for philosophy of law, or for judges, or for those who are making a constitution, or for international law, when it comes to determining whether a legal order has authority, is to see whether that legal order is effective. That's all that matters, which is why in this opinion, I think he could say, and I would be interested to read that opinion, for a reason I'll speak to in a moment. We've talked a bit about this. All he thinks one can say is this legal order operating? If it is operating, it has authority, and things should go on. And he thinks that that's all that international law can say about it. And actually, this is the stance that is generally taken by international law about whether there's a legal order, whether there's a state that should be recognized, is does it meet certain criteria of efficacy, including having, and I think this is one, they're having a legal order that's more or less working. Why? But then for Kelsen, there's this very complex account of what it is for a legal order to work. There's got to be a constitution, a hierarchy of norms. Certain things have to happen, and in that legal order, there will take place the phenomenon that I pointed to earlier, that he calls the transformation of might into legal right. And what I try to do more at length in the book is to show how this transformation results in what I call a conversion process, where in a way, brute political power gets converted into something legitimate because it's required that it manifest itself through the complex workings of a legal order. And there I take my major inspiration from Kelsen. So that's why I think there's a, it might be that my answer to both questions is the same. So just one more thing before I ramble on for too long. Well, one of the reasons why I was so fascinated when Arthur first told me about this opinion that Kelsen delivered for Brazil in the 1930s is there was this huge debate in common law countries in the 1950s and 1960s, which I deal with in part in the very last part of my book in Appendix 3, about what happens when there's a coup. So in Pakistan, where there was a coup after coup in the 1950s, and then the courts would ask themselves the question, because there would be a challenge, can we operate legitimately when there's been this radical change of government? They would reach for Kelsen in order to explain why they felt legitimate in continuing to do their work. So you get these judgments coming from, I forget what the court is called, let's just call it the Supreme Court of Pakistan in the 1950s, where you have paragraph after paragraph of Kelsen quoted in the judgment in order to reach the same conclusion that Kelsen delivered in this opinion. And then in the episode that I know best, because it happened in the next door country to mine, South Africa, in Rhodesia, in 1961, Ian Smith, the head of a racist white government, declares unilateral independence from Britain and sets about putting in place a system which is rather like the apartheid system further to the south in Southern Africa. And then there's a challenge to the courts that they should not be inflicting the death penalty on people. Why? Because there's been this revolution. It's not clear that the courts, which get their authority from the old constitution, can operate under the new constitution that Ian Smith's government has put in place. And what do the courts do? What does the court do? It reaches for Kelsen. So with one dissent, the judges say, well, we're not going to say whether we're operating legitimately or not. That's another issue. Maybe it'll take a few years before we can know that we're operating legitimately. But we know that there's a valid legal order in place, and that's all we need to know that we can do our job as judges. Kelsen never commented on these cases. Even though there was a heated jurisprudential debate in the 1960s in English about the implications of these cases for philosophy of law. And as I think I mentioned to you, Finnis's first important piece in jurisprudence, Revolution and Continuity in Law, is triggered by this decision of the Rhodesian High Court in a case called Madzim Bamuto and v. Lardnerburg. So I think actually this opinion, which is, I think, unknown in the English-speaking world, actually does tell us what Kelsen thought. And what Kelsen thought is that the judges in Pakistan and Rhodesia got things right, at least from the legal theory perspective. But I also wonder, so going back to what I said a little bit earlier, whether that's really consistent with Kelsen's understanding of the complicated way in which legal order works. Right, so that's a rather rambling response to two very interesting questions.
Thank you, David and Arthur. I think we can open questions for the audience now. Professor Ronaldo, Daniel.
Well, thank you very much, David, for your presentation. The first point I'd like to ask you, I was a little bit puzzled by the title, Legal Positivism and Totalitarianism. And when you started your presentation, you even mentioned Hobbes and also use as a kind of replacement for the word totalitarianism, authoritarianism. So I was wondering, why are you using the both concepts, since they're usually we usually understand them as not completely, but very different concepts. And in your presentation, it seems that you were more focusing on the authoritarianism than totalitarianism. So my second point is related to this, which is you didn't really mention, at least not directly, the accusation that is usually made against legal positivism, that it leaves too much space for the discretionary power. So in this sense, when we take the model of legal interpretation that is implied by legal positivism, it leaves a lot of space for judges to use their discretionary power in the strong sense, as Dworkin mentioned in his famous article, The Model of Rules. So, and the alternative theories like natural law or even law's integrity tends to show or to insist that there is less discretion or less strong or no strong discretion when law is applied, and this is a kind of countermeasure for authoritarianism. And my third point is more speculative. When I noticed the title and when you were describing why, how you get to be invited and excited about writing this article, I was wondering, what if the question was about not legal positivism and totalitarianism or authoritarianism, but about the relationship between natural law and authoritarianism? And I was thinking about, for example, the kind of authoritarianism and sometimes even totalitarianism that is at place when we think about theocratic regimes deeply rooted in a vision of natural law that in a way controls all dimensions of private law and public law, life.
Right. So I think I got all three questions, but you can tell me if I missed parts of them. So in answer to the first question, totalitarianism and authoritarianism, all I can do is kind of elaborate my confession with which I started the paper. And that is, in this paper, I confess, I ride roughshod over this distinction. And it's probably right that I start to talk about authoritarianism more than totalitarianism. Why? Because I didn't actually like the task I'd been given. So I talked about what, so this is why it's a confession. I talked about what I could talk about, and I agree that there is this distinction and I don't address it. So mea culpa, that's what I can say in answer to the first question. But I think there is a really interesting issue there. And so I think it is the case that all totalitarian regimes are authoritarian, but I think one can have an authoritarian regime which is not totalitarian. So, for example, someone like Schmidt, whom I'll talk about on Friday, there is a sense in which Schmidt is authoritarian but not totalitarian, because he did not want the state to be like the Nazi state, which is ready to dictate the whole of social life to those who live subject to it. He wanted an authoritarian state, but I think not a totalitarian state, although when the totalitarian state came along in 1933, he signed up to it until they got tired of him. Okay, the space for discretionary power. I think that's a very interesting issue. I touched on it only kind of glancingly in my talk. And I touched on it glancingly at the point where I said, well, if one starts with part 5, what are the purposes or values that we take legal order to serve? And then we go all the way back to 2, the Cordon and the Penumbra, we'll find that what positivists portray as discretion as Hart portrays it in 2, that was a part 3, sorry, part 3, that tends to vanish because it gets filled by the judge's sense of the values in light of which the judge should interpret the law. And there's an interesting passage in part 3 of the Positivism, the separation of law and morals, where Hart imagines a judge who adopts what is really Dworkin's theory of interpretation, even though Dworkin hadn't yet come up with his theory of interpretation. And Hart at that point wants to rebut the charge that it's a kind of ad hominem point. If one had a Dworkinian theory of interpretation, this would still not show that there's a necessary connection between law and morality. Why? Because when the judge works out what the principles are that underpin the law, the judge might find that these are awful moral principles. And so that would tell you that there's no necessary connection between law and morality. And Hart adduces as an example, and this I do talk about in the paper, though not in the presentation today, an example that comes out of these grudge informer cases. And so Hart says, well, imagine that a judge in Nazi Germany understands that the laws that make it a crime to insult high-up officials or undermine military morale is there just for the purposes of intimidating the population. And so the judge understands the principle behind the law, interprets the law in that light, and there you have a kind of advanced refutation of Dworkin. The judge doesn't think that the judge has discretion, but just look where that takes us. There's a wonderful article which is not well known today, which I use in my courses and which I talk quite a lot about in the paper and more in my book, by a German who ended up in Australia after the war called Helmut Papper in the Modern Law Review. And Papper looks at the way the grudge informer cases were decided, points out that Fuller and Hart, through no fault of their own, had a complete misunderstanding of how these cases were decided. But in regard to this point of Hart, where judges would think that the principle behind the law that they should use to interpret the law is intimidate the population, Papper kind of throws up his hands in consternation. He says, how can Hart think that that could ever be a principle in any legal order, that one should interpret the law according to what will most intimidate the population? And I think that idea is in tension with the things that Hart says elsewhere. So, for example, in chapter 9 of the Concept of Law, Hart has a few lines which mostly get neglected, where he sets out what he says to be, considers to be the judicial virtues, how judges should interpret the law, according to some general principle of justice that underpins the law, he says. And so you get Dworkin in a few lines in the Concept of Law. And so the point I think I want to make is that whenever Hart looks at what judges do, from what Hart would regard as the internal point of view, discretion vanishes. Why is discretion there in the debate? Discretion is there in the debate because that's a legacy of Bentham and Austin. Bentham, and this I did allude to in my the last words of my presentation, Bentham wanted to get rid of discretion. He didn't want judges to have discretion. He didn't think that you could do without judges, but he wanted to marginalize them to the extent possible. Why? Because when judges adjudicate, they're exercising, it's a kind of mini legislation, and judges should not be legislating. Austin brings judges back into the picture. Why? Because he thinks it's a good thing that judges legislate and legislate much more than they're doing, because he trusts the judicial elite more than he trusts the people. And that then creates a space in which debate happens in the 1950s and afterwards. And I think that one of the issues on which Dworkin was 100% right, although he didn't put it quite this way, but it's in line with many of the things he said, is if you want to take the internal point of view seriously, as Hart told us, we have to take the internal point of view seriously if we're going to understand law as a matter of authority, then when we look at the internal point of view of judges, at least as they present themselves officially, they will never say that they have discretion. So we have to investigate what happens in the space without thinking of it as a space where judges can just do what they like. So I think that's the answer to the second question. The answer to the third question, natural law and authoritarian, what did you say, totalitarianism or authoritarianism? I forget which.
Authoritarianism.
So I think there is this, an association between a certain natural law tradition and authoritarianism. And it's a phenomenon that I think is actually quite present in our world today. So if one looks, and I've talked to people about this over the last few days, and maybe I'll say something about it on Friday, if one looks at the idea of common good constitutionalism, which is now being put forward by Adrian Vermeulen and a bunch of people in the United States, and then there's a link, there's actually a common good constitutional project that links Vermeulen to people in Oxford, notably Finnis, and then his main protege, Richard Eakins. They're all trying to work out an idea of the common good in light of a certain understanding of natural law. And I think that's a very authoritarian understanding of law. Why? Because, and it has something, it's a bit like the way that Hart understood Radbruch. What is law? In order to understand what is law, we have to look to moral standards that are external to law. And of course, if you're a liberal and your moral standards are those of liberalism, then you will decide whether something is law according to the values you associate with liberalism. If you're some kind of Schmittian like Vermeulen, you'll think that the standards are very different, so that your understanding of the common good will be very different. When Fuller and Dworkin said about criticizing legal positivism, to the extent that they would describe themselves as natural lawyers, they did not work with this understanding of natural law. For them, the standards for evaluating law were all internal to law. And I think that makes a big difference. And actually, maybe, this is what I claim in my book, establishes some kind of common ground between Dworkin, Fuller, and Hart and Kelsen. And what I also claim at some length in the book, in a shorter version in the paper, is that actually Radbruch is best understood not as putting forward a conception of law as positivism with a minus sign, but as setting out criteria internal to law, the values that he associated with legal order that he set out before the war, that judges had to take heed of in interpreting the law. And then again, discretion vanishes, to take us back to the second question.
Hi, hello, David. And many thanks for your presentation. It's a really thought-provoking topic. I suspect it's one question on two fronts. I'm pretty sure those things are connected, but I'm still working on the connection in my mind. The first thing is regards one topic we talked about a little bit on Monday, which is Gardner's claim about law being normatively inert. And I think that's an important point, because if I understood you correctly, part of your argument against positivism is that, well, law is not normatively inert. Law is something that people take seriously. So if you're taking law seriously and you're assuming the separation thesis, then we might end up with ideological positivism. Therefore, we should dish out the separation thesis. That's more or less your claim, right? So if that is, I think there's an issue there in the sense that, well, I'm not sure that the best understanding of legal positivism's claim about the inertness of legal normativity is that law simply doesn't matter at all. I think if you think about, let's say, Andre Marmor's norms, reason the law, or David Enoch's reason giving in the law, the thing they're trying to point out is that, well, law, of course, law is normative, but legal normativity is conditional on whatever other reasons you might have to care about the law. So if that is true, then, well, yes, if the law is nice, then you ought to follow the law. If the law is not nice, then you ought not to follow the law, and that's perfectly fine. That's more or less the way that both Enoch and Marmor go on talking about legal normativity on those two papers. Well, laws, and Enoch actually says that, well, law sometimes gives us moral reasons to follow the law, and sometimes it does not. And he goes on saying that this is actually trivial, and that's why he doesn't think that a lot of jurisprudence is interesting in his view. So that's one thing about the relationship between legal positivism and an account of legal normativity. If I understood those guys correctly, they're saying that, well, legal positivism doesn't actually have an account of legal normativity. So what does legal positivism do then? Which is the second point, which is in your paper, you talk a lot about the separation thesis. However, one might put pressure on that point by claiming that, well, yes, that's one way of describing legal positivism, not necessarily the most accurate one, in the sense that if you look at what Raz is saying, for instance, we have maybe the best way of thinking about legal positivism is not on the terms solely of the separation thesis, but on the terms of the sources thesis. And this changes the picture a bit, because the idea of this social sources thesis is that, well, if you want to determine the contents of the law, then you need to look at social sources alone, and then you can determine the content of the law. So that's if that is the case, then again, this allows legal positivism to put some distance between itself and the charge that will collapse on ideological positivism. Because if we're only looking at the sources, we're only determining the contents of the law, and this tells us nothing about the other point about legal normativity. We're just determining the content of the law, which I think is one of the reasons why someone like John Gardner goes on saying that legal positivism is, at the end of the day, only a theory about legal validity and not a broader theory about law in general. I think that's my question. I would like to hear you more about those two sort of criticisms. Thank you.
Right. Thank you again. This is going to be a different kind of confession. It's not, well, I had this title, but actually I don't deliver on it, which is kind of mea culpa. There's a different confession. I actually just don't understand Marmor and Enoch when they make these claims. So if you care about the law, then the law will give you reasons. Well, what is it? We cannot but care about the law. Why? Because if we're fortunate enough to live under the rule of a well-functioning state, then we have to care about the law. Why? Because we're constantly being told what to do by the state. So what's our relationship to the law of that state? We can't say we don't care about the law. We have to care about the law. And what are our reasons for caring about the law? I think that people like Marmor and Enoch have an excessively moral understanding of why we should care about the law. And I would want to substitute, and this is my Hobbesian side, a political reason. Why should we care about the law? It's not because the law that happens to be made on an issue corresponds with my sense of right and wrong. It's whether the state provides for me a legal order which makes it possible for me to interact with my fellow subjects on peaceful and stable terms without diminishing my subject status. So it doesn't turn me into what I called on Monday a second-class citizen. I think one gets a very different picture of the authority of law and why it might be legitimate authority if one switches from this individual who's saying, well, does the law meet the conditions that are set by Raz's normal justification thesis? If it doesn't, I can say the law doesn't have legitimate authority. It's just de facto authority. I don't care about it. I can ignore it. That's this kind of very moralized reading of the legitimacy of law. And actually, when we talked about Bernard Williams earlier, when we first met, I think Williams was trying to move us away from that understanding of legitimate authority when he criticized liberal moralized theories of legitimacy. So that's the move I'd want to make in response to the first question. In response to the second question, in some ways, it's the same as my response to the first. It's a confession. I actually just don't understand what these people are saying much of the time. So I was at this conference, I think it happens on a yearly basis, in the early 90s, the International Association for Legal and Social Philosophy in Bologna. And Raz was one of the keynote speakers. And after he'd given his talk, a fellow stood up. I think he was from South Korea, but at any rate, he didn't have much English. So it was quite a halting question. And all you could really understand from his question was that it started with the claim that you, Joseph Raz, as a legal positivist, think this. Raz stood up and he said, I'm not a card-carrying member of any party, let alone the legal positivist party. And he sat down. That was his answer to the question. And then he realized, which was unusual for him, that he'd actually been quite rude to this person. So he stood up and tried to give an answer to the question. So Raz claimed most of the time, well, I don't even know what legal positivism is. And it's the same sort of claim that you get when people, Hart never held to the separation thesis. Hart himself wasn't a legal positivist. So it becomes quite difficult to work out what the debate is about in any regard. So the sources thesis, well, of course, Raz says, in a way, let's focus on the sources thesis rather than the separation thesis. Why should we focus on the sources thesis? The sources thesis, I think, in Raz is entirely driven by his conception of authority, which is a conception of authority that is not a conception of legal authority first and foremost. It's a conception of authority that you work out by just reflecting on the idea of authority, and then you put that idea of authority into law, and you say, well, because this is correct, the correct conception of authority, if law has authority, this is law's conception of authority. So just one more thing about the sources thesis and why I sometimes just don't understand what Raz is about. So Raz wrote this quite nasty review of Dworkin's A Matter of Principle. I don't know whether you've read this review. And in it, he has something to say about the sources thesis. And he says, what Dworkin hasn't understood is that all that the sources thesis does, and all the sources thesis was ever meant to do, is to identify the sources of law. And the implication he takes is that that's all the sources thesis does. It doesn't do any work for judges or other legal officials. It can tell judges, well, there's the Constitution, there's legislation, and after that, and this is going back to one of Ronald's questions, it's all discretion. So the sources thesis can't do any work for us. So what is the place of the sources thesis in Raz's theory of law? I was on the committee of a student who finished last year, was it this year? Actually, earlier this year at New York University, and I've mentioned this to someone over the last few days, I forget who worked on coherence in legal theory. And a lot of the thesis is about Raz. And he finds in Raz, and I think this is probably right, a deep ambivalence in Raz about coherence. That Raz sometimes wants to embrace coherence and sometimes wants to say, no, there's something really wrong with the idea that we should understand law as coherent. Why is he worried about that? When he says, when he's worried about coherence, he's worried about it because of the concerns that he raised about Dworkin, that it will turn into some kind of spurious moral idea of the obligations that law creates for us. So I just think, in answer to both questions, that there's huge confusion in legal positivism about this and ambiguity. And what I claim to do in the book is to sort out all of that confusion by going back to my favorite political and legal philosopher, that is Thomas Hobbes.
Thank you, David, for this wonderful lecture. And I'd like to make two comments. One quick one about Arthur's intuition regarding the idea of autoridade, that's authority in Portuguese. And I think you have something there, because if we think about not authority, but authoritative, we don't have a word in Portuguese for that. We have to translate authoritative for competent or trustworthy or something on those lines. Yeah, we have authoritarian that can be a translation for authoritative. Yeah, so authoritative is not authoritarian, right? So we don't have a word for authoritative. And that's difficult to translate ras, because we just use this word that we don't have in Portuguese, that it's autoritativo. And actually, I think this is interesting for us to think about the nature of authority, or what is authority whatsoever. And Ras says in those earlier essays in The Authority of Law, he says that authority what distinguishes authoritative directives is their special peremptory status. Authoritative directions must be peremptory. And that suggests to me that he's linking the idea of authority with this possibility that the subject doesn't have to reflect anymore. In that sense, is a service. And in that sense, the subject can adopt the reasons given by the authority. So yeah, so going to the second part in my question more properly, I'd like to hear from you, David. How do you think that Hart ended up with this paradox? And in other words, what came in his way of really thinking about authority as a reflective relational activity? Because when you talk about authority, you have to presuppose a relation, right? And it's a recognition relation, because to be an authority, someone has to be recognized as an authority in some sense. And what came in Hart's way? I think we can think with working that what produced this blockage of the internal point of view, because I think Dworkin saying precisely that what is wrong with Hart is that the internal point of view is blocked, contrary to what he was trying to state. Dworkin says that this was Hart was wrong on that regard because he cared too much about conceptual analysis. The problem was the method, so to speak. Do you think that is correct? Or maybe can we think of another explanation for this blockage in Hart? And maybe can we read Hart as trying to find a way to show law as a social practice that actually make people's life easier, in the sense that they don't have to deliberate all the time about their reasons. And I think Ras developed something on those lines. And for this reason, we can say that he starts with the separation thesis. And when he says, and you said that on your paper, on the conclusions of your paper, you say that why was Hart so insistent on that you argue it's a mistake? And I agree, it's a mistake. You say that Hart's conviction, the explanation is Hart's conviction that the separation thesis sheds valuable light on the morally complex situations faced by legal officials and subjects in practice. So he was trying to say law is something we can trust, and in that sense, it has authority. So which explanation do you think is better, something along these two, or I don't know, maybe if you can comment a bit on that.
Sure.
Thank you so much.
Sure. Thank you very much, Luciana. I think I'll try to answer the first question by, how much time do we have left?
We're going to 12 p.m. or 12 to...
I would say another 25 minutes.
Okay, yeah. I just got to try to time my answers a bit. I want to try to answer the first question by going back to the person I've mentioned a couple of times as my favorite guy. That's Thomas Hobbes, because the whole of the discourse about authority that Hart embarks on and then Raz takes over is actually deeply informed by Hobbes. And it's informed by his distinction in chapter 25 of Leviathan between command and advice. And Hobbes says that the difference between command and advice, or counsel as he calls it, is that when someone commands one, then one acts on the basis of that person's say-so. Whereas advice, I just add to your stock of reasons and you can take or reject my advice as you want. And so there is this quality to command, which is peremptory, as Hart puts it in Essays on Bentham. And but for Hobbes, it comes out of a relationship between the commander and the subject. So this is in a way getting a bit into your second question. I think what vanishes in legal positivism is that idea of the relationship. And actually what makes that idea vanish are Bentham and Austin, particularly Austin, because Austin says in his lectures that the two most important figures for him in terms of influence on him is Bentham, the more important, but Hobbes is almost as important, except for the social contract, he says, which is a lot of mysterious nonsense. So ditch that part and keep the rest. So the relationship vanishes, and then I think one gets just the idea of peremptoriness, which travels together with another idea, which one finds in Hart, which is content independence. And that idea of content independence then becomes, I think, Raz's sources thesis, that we've got to work out the content of the law without regard to moral considerations and argument. And I think the big difference between Hobbes and, in a way, his positivist successors, like Hart and Raz, is that Hobbes rejected the content independence thesis. Why? Because he thought that when it came to interpreting the content of the law, judges had to interpret the content of the law in light of their understanding of Hobbes's extensive list of the laws of nature. So that means your commands are peremptory, but one has to be able to interpret them in light of the laws of nature. And if they can be so interpreted, that will then establish a relationship between subject and ruler, which otherwise doesn't exist. And I think one of the problems with Hart is that while I do think, so this is moving into the second question, while I do think that one can get an account of law of a sort that I like, and I think that you like, where law is a social practice which people should be able to trust most of the time, unless there's something in it that takes him by surprise. Hart cuts himself off from giving that kind of account. Why? Because he feels obliged, I think for reasons that have something to do with the separation thesis, to say that the only important relationship for legal theory when it comes to authority is between the lawmaker and officials. So the subjects might obey just because they fear that would be very bad, but you could still have a legal order in place. Once you bring the legal subjects into the picture, I think things start to change, because then the question becomes, well, what is the relationship of authority between them and the ultimate lawmaker in the society? And Hart was very concerned about that, but was quite worried about getting involved in elaborating that kind of idea. Why? Because he thought he would then end up with an idea of legitimacy rather than just an idea of authority. So I agree with what you suggested as the reason for Hart's blockage.
Hi. So thank you, Professor Dyzenhaus, for the lecture. I have two questions. One bonus question, if you are comfortable in answering.
Yeah.
So the first one is, as far as I could understand, so Hart, like the lesson to be learned is that Hart made a very bad depiction of Hartbruch, Austin, and Benson's account. And but it is possible to make a way out of this connection between positivism and totalitarianism or authoritarianism. And I was going to make this question, but then Professor Ronaldo already stated it, the connection between authoritarianism and natural law. But I want to put like the reverse side, like totalitarianism and natural law, because I think the danger may not only be on positivism and totalitarianism, but also it was in natural law and totalitarianism. And Frankl and Neumann, they also talk about it in their books. And Frankl talks about these communal natural law. So there was this preoccupation with justice in National Socialism and how should we cope and understand it. So this is the first question. And the bonus question is maybe ungrateful. So how would you frame your position in this conundrum? So would it be possible to say that you are an unorthodox natural lawyer? Because you try to reject this common separation and divide between natural law and positivism. So there are common grounds. So how would you frame yourself in this way?
Do I get a prize if I answer the bonus question?
Yeah.
Yeah. So I'm really happy that you asked, well, both questions, but in particular the first, because something like an answer to it was hovering around in my mind when you, Ronaldo, asked your questions, and then it escaped me at when I was giving my answer. And it's very helpful to me that you bring in Frankl and Neumann, because I think there is a tension between totalitarianism and legal order. I think it's very hard to have a totalitarian government, properly so called, that exercises its power through legal order. And Frankl, whom I talked briefly about on Monday, and perhaps Neumann at times, maybe not so much in Behemoth, but certainly things he said before Behemoth and then after the war, did not think you could implement a totalitarian ideology through law. They would put such a strain on legal order that you would have to govern by some other means, which is why I think Frankl comes up with his diagnosis of the Nazi state as a dual state. And Fuller had much the same idea, right? That just you can't make a knockdown argument about why, when there's a legal order in place and it's functioning properly, that there'll be moral law, but you can show that certain kinds of immorality are very difficult to implement through law. And I think one of those kinds is the morality of any kind of totalitarianism. It puts a huge strain on legal order. Why? Because legal order works in these complex ways, and totalitarianism can't live with that kind of complexity. Actually, Finnis, if you look to his chapter on the rule of law in natural law and natural right, which is very Fuller inspired, has a paragraph which makes this point, I think, quite beautifully. So the bonus question about how I would describe myself. So the project of my book is to get away from these labels, legal positivism and natural law. So I don't want to call myself either a legal positivist or a natural lawyer. And I certainly don't want to be thought of as a natural lawyer who has some, I don't know, kind of metaphysical account of moral values that stand outside of the law. I'm interested in an account of law that makes sense of law. To go back to the slide where I just had a sentence from Norberto Bobbio, that the juridical experience is a normative experience. What is it to have a normative experience of legal order? And I think all of the major philosophers of law are trying to work out that idea, and that's what actually creates the common ground between them. Yeah.
We have time for one or two more questions. Sure. So,
Do you have anyone else?
não, claro. Podemos fechar.
Well, first of all, in your article, you characterize the dilemma. Sorry, I'm gonna sit. Yeah, the dilemma that Hart faces as either accepting the force of the charge that positivism encourages totalitarianism, or accepting that the authority of law is always to some extent legitimate. In the conclusion of your talk today, if I understood you correctly, you said legal positivism must or should ditch the separation thesis as a way of conceding to the necessity of legitimate authority. In this argument, it seems central that legal officials regard this authority as legitimate and try to work the law pure, as it were. But does this not require one to see legality or the rule of law, as an expression you used in another paper, as the rule of liberal principle? That's to say, the legitimation of authority will depend, it seems, on contingently shared values of the community in which it is encumbered. So that's basically my challenge to you. Does this revised view of positivism not depend on a contingent set of shared values within a community? Or is it something that you can find in any legal system, any mode of governance that claims to be legitimate authority in a way?
I think the answer to the question is that wherever there's legal order, there will be not only authority, but legitimate authority.
Yeah.
And it, in a way, goes back to my answer. Sorry, I forgot your name. Is it Marina? Yeah, Marina's question that it's quite difficult and maybe even impossible to implement certain ideologies through law. What are the ideologies that you can't implement through the workings of legal order? They're ideologies that reduce the status of persons in a particular group to severe second-class status or worse. That's very difficult to do through legal order. Hence, the struggle to make slavery into an institution that's created by law. There are all sorts of tensions that arise in all slave-owning societies. Why? Because for some purposes, enslaved people are regarded as legal persons, and in other respects, not. That creates huge tensions in the legal order. So I think any legal order will, to some extent, be legitimate, and there'll be a kind of limit on what kinds of values a society can contingently hold and still rule itself by law. But it still might be the case that the legitimacy will vary greatly from legal order to legal order. And my desire to get rid of the separation thesis does not preclude the stance of the individual subject who says, sorry, that's so immoral that I don't regard myself as bound by this law anymore. So I don't want to get rid of that perspective of the person who wants to stand outside of the law at all.
Yeah, sure, but I'm thinking we can think of cases like Sharia law, which grossly discriminates some kinds of people, namely women, has inhuman punishments to a lot of crimes. Would you not say that's a legal order in a way? I think it seems that we use law a lot of times in this way. And you mentioned the Finnish chapter on the rule of law. It says, we have almost two concepts of law. One which is the core case, and one which are like degenerate cases of the use of the term. But to me, this does not circumvent the case of the legal authority, the legal official, who has to see law as legitimate and should work law pure in a way. It should interpret it in its best lights, considering the values that are shared within this community. But if this community is grossly unequal and illiberal, those will be the values that will influence the most in the interpretation of law.
Well, my way of answering this kind of question is deeply influenced by biography, right?
Yeah.
And by my experience of being part of the privileged white minority, of growing up and learning about law in apartheid era South Africa. And it was very difficult for the apartheid government to implement the policy of apartheid through law. In fact, they never succeeded in any of their aims. And because they were committed to ruling by law, that actually put a limit on what they could do in implementing their ideology. And I'm very interested in why it might be the case that a commitment to ruling through law places a limit on what kinds of ideologies you can implement through law. So that is not going to tell you that every time there's a functioning legal order in place, everything looks great. Things might be terrible, but there's a limit, I think, to how terrible they can be. And I think that tells one that there's going to be some legitimacy, at least in every country in which there's a functioning legal order.
Look, sorry. I don't think I actually have only a short comment, and it's on something that Artur said. I hope it's not very nice to comment on the comment, but about the word authority. Maybe because I'm not a legal philosopher, I'm from constitutional law, and I don't think authority in Portuguese has this connotation of de facto authority. I think you have both, and the fact that in English you have authoritative as an adjective that you don't have in Portuguese says not much about it. I think the word autoridade in Portuguese, it's both ways. It works both ways, I think. And I had a further question, but it's too late. I'll refrain. No. It will be another author claimed to correctness developed by Robert Alexi. But
I could tell Alexi was coming.
Yeah. Okay, that's it. But you don't have to answer. Thank you very much.
Just quickly, two things. One, I disagree with the description you gave of yourself at the beginning. I think all constitutional lawyers are philosophers of law, whether they admit to it or not. Second thing is, I think Alexi has exactly the same problem as Raz. That is, it's all a matter of law's claim to Richtigkeit. And I think that although this is something I should probably be more careful about saying, but I'm going to say it anyway. I think Alexi gets Radbruch wrong in more or less the same way that Hart gets Radbruch wrong. And one shouldn't say that because Alexi is one of the great interpreters of Radbruch. But I think he also tends to think of Radbruch as positivism with a minus sign.
Just to be clear, I used autoridade in this paper. I asked a couple of British friends of mine, and they gave me the Webster's definition of authority, and it corresponds almost exactly to Hawaii's definition of autoridade in Portuguese. So I considered this point. Although I still think that we tend to use the word in at least Brazilian legal theory when they're not commenting authority in English in a way that sounds a little different to me. But that's all.
So thank you very much for everyone that came by. Thank you, David. Arthur, declare the conference closed. Thank you.